We are in day 2 of this hearing process where Judge Jackson is answering questions. Each member of the Senate Judiciary Committee has had a half an hour to question her. They're currently in a lunch break. They will resume that questioning again shortly. But so far, a lot of focus has been on her judicial philosophy, as well as some of her sentencing background, her history as a lawyer, her history as a judge as well. Let's bring in the former president of the National Bar Association, trial attorney C.K. Hoffler, for more on that. C.K., thank you for being here. What stands out to you from some of the questions asked so far and how Judge Jackson has responded to them?
Well, what stood out for me, quite frankly, was Lindsey Graham's battalion of questions, sometimes soliloquy, aimed at, I think, getting under Judge Ketanji Brown Jackson's skin to throw her off her game. But what really stood out for me was the fact that she was able to, while under fire, maintain her cool. When she spoke, when challenged on being lenient, or the accusation that she was lenient as related to child pornography and her sentencing relative to those types of cases, I think we saw truly the type of compassion and passion that she will bring to the bench as a justice of the U.S. Supreme Court. Very appropriately so. She defended her record because I think she really took strong offense to any accusation that she would be lenient or would step over the line as related to sentencing of those who had been accused or found guilty of child pornography. And I think that probably gave us insight into her spirit, her soul, and things that are important to her. What I also felt was very good is she stayed in her lane. I'm quoting her. She wanted to stay in her lane. She threw back information to members of Congress or to the senators when they tried to trap her or cause her to get off her game. She threw it right back at them very nicely, very politely, because she made it a point of staying in her lane, making sure that everyone understood she believes in the Constitution, she loves this country, she believes in the rule of law, and she understood clearly and understands what her role is as a judge, as a federal judge, Federal Court of Appeals, and she will understand what her role would be on the U.S. Supreme Court. So I think that she was very skillful in doing that. And I thought that her methodology, her application, her way that she dissected the three buckets that she considers when tackling a case and how she approaches each of the cases, I thought was particularly effective. And I think, of course, Senator Durbin helped because with his offensive tactics, when I say offensive, I'm talking about a football offensive play by introducing the notions, the hot spots to her in the beginning so that she could respond, throwing her some softballs, so that when the senators came back trying to be obstructionist or very difficult with her, she had already answered the questions, and that took the steam out of any points that they were trying to make. So I think overall she's done quite well under fire.
She has been more broad with some answers than others, but she answered with a lot of specificity to this line of questioning about her child porn sentences. And she explained that the sentencing guidelines, when developed, were developed in kind of a pre-internet-ish way, where they are designed to punish more heavily those who have acquired more material under the guise of someone actually getting this material in the mail and the amount of effort that it takes to get that. And she said, in these cases, we were sentencing, or in the case they were asking her about, we were sentencing someone who acquired this material through the internet, which is a different sort of ballgame altogether. And so the sentencing guidelines no longer differentiate between the severity of the violation because the material is acquired differently now. Why do you think she chose to be so specific in the answer to that question?
I think she was trying to point out sort of the difficulty with sentencing guidelines, the difficulty with what members of Congress could do, by the way, she was throwing it back at them, what they could do to change some of the sentencing guidelines so that it might be easier and more consistent for judges to apply the sentencing guidelines uniformly. And I think she felt very strongly about that because of the implication that somehow she would let child sex offenders off, knowing the devastating impact on victims of child pornography or sex offenders, that the types of heinous acts committed against children. So I think she wanted people to understand the distinctions, wanted people to understand what Congress's role is in sentencing, and wanted people to understand that when she was on the U.S. Sentencing Commission, some of the things that she did and the broad recognition that there's a problem and a need for reform with some of these sentencing guidelines.
And Senator John Cornyn, as well as Senator Feinstein, both asked her about stare decisis, or precedent, when it comes to Supreme Court decisions. She answered just sort of broadly explaining what stare decisis means, what precedent means, and how a justice is supposed to go about judging a case while considering that precedent. What role does precedent play, and what do you make of Judge Jackson's answers so far every time that comes up?
Well, I think the role of the precedent it's very important, because whether you sit on the U.S. Supreme Court or federal court or state court, whichever court, you've got to look and see if there's a precedent. Is there other case law? Has this issue already been determined, ruled on? Because you have to be guided in part by that. I think the way she answered it was actually quite fitting. What she said is, of course, precedent is important. That's one of the factors that I consider, because certainly you don't want to be out there as an outlier when there's a clear precedent on the case. And I think she just wanted, that's a point, I think that was a softball for her, where she just said, look, I could answer this in my sleep. Of course, precedent is important. This is how I would look at it. And my consideration, there are three buckets that I look at. One of them is precedent, case law, what's out there, because certainly I don't want to be on the wrong side of things. And the fact that she's only been reversed very few times, 2% of the times, much less than most other judges in her position, speaks volumes about how she takes that seriously. So I think it was a softball, and I think she answered that really well, without even thinking twice about it, because I think that that's an area of comfort for her.
She was also asked about abortion rights. She agreed that Roe v. Wade and Planned Parenthood versus Casey are precedent at this point. They are settled. The Supreme Court is currently considering a Mississippi case that's a direct challenge to Roe v. Wade, however, and she didn't call it a super precedent. So what are her answers there indicate, and how does stare decisis apply here?
Well, I think she was vague enough, because she understands that that's probably an issue that is going to be, not probably, if she's confirmed, that will be an issue before her with the U.S. as a justice of the U.S. Supreme Court. So really, she could not comment any more than she did comment. It was very important for her to be vague, for her not to take a strong position one way or the other, because that's going to be something that she's going to encounter. I'm claiming that she's going to be confirmed. I think it's pretty, I hope that she is confirmed, but that's going to be an issue she's going to have to tackle. So it would have been ill-advised for her to go into any greater detail. She needed to be vague, and I think most people sitting in her spot would have done just what she did in answering that question. She understands that there are challenges to Roe v. Wade, and everyone knows that. So I think she just went middle down the line. She did what most judges would do in that circumstance, and I think it kind of stopped the discussion, because there's no place else you can go with her response, which was appropriate.
Now, Republicans have zeroed in on her work representing a Guantanamo Bay detainee, in which they're saying she referred to then-President George W. Bush and the Secretary of Defense as war criminals in the argument supporting this detainee. When asked about it, she said she doesn't remember that argument. It's one of the few times that we hear her just saying, oh, I don't remember having written something or having said something. What did you think about her argument here and this overall line of questioning? Why is it important?
Well, I think this was actually kind of dicey for her. I was surprised that she said she didn't remember, but she's probably authored and been on so many cases, and that was quite some time ago. But I would have imagined that in her briefing, somebody would have said, look out for this. But she drew the distinction. She said, look, and I understand this because I'm a trial lawyer. When you represent your clients, you are a zealous advocate when you represent a client. I was representing clients who basically did not have the ability to retain counsel. I was, these are the issues. You don't get to pick and choose the cases that you're going to take. This was what I did on an appellate level, and that was what I must have felt should be the position to prevail for my client being a zealous advocate. That's what criminal defense lawyers do. And that's what she was doing. So I think in sort of bouncing back to this is what criminal defense lawyers do. They defend their clients. They're zealous advocates. I don't recall, labeling that. What she was saying is there's probably a different context there. I don't have it at my fingertips, so I'm not going there. I think that was wise, but I think it was really dicey. But she probably wanted to shut down that line of questioning because she didn't have the information at her fingertips. And you certainly don't want to navigate in those type of troubled waters without having all the facts in front of you laid out before you that you studied. And that's one thing that she does. She prepares. If you notice, a couple of times when she wasn't comfortable answering something that was just given to her on the spot, she said, you know what, Senator, I really can't. I haven't done analysis on that. I can't give an answer. On this, even though she wasn't denying that she said that, she just said, I don't recall. And the way I interpret it is, I don't have everything in front of me, and I'm not going to take or go any further on this until I have all my facts in front of me.
And Senator Chuck Grassley also asked if Judge Jackson considers the Second Amendment a fundamental right. She responded clearly to that, saying the Supreme Court has established the Second Amendment as a fundamental right. So what does fundamental right mean in this context? And why answer in that way, saying the Supreme Court has established rather than, yes, I think it's a fundamental right?
I think that Judge Ketanji Brown Jackson is trying very hard to distinguish between and to not inject what she personally feels, because remember, she's taken the position, it's not really important what I feel personally. I am an independent jurist. I'm going to look at the law, follow the rule of law, and then rule to the best of my ability. She's trying to establish that it's not about what she feels personally. It's about what the Supreme Court has already ruled on, and that's the law right now. I think that was one of those instances where she's down the middle. She's making a wise decision. It's not about what I feel about the Second Amendment or any of anything personally. It's about what I would be committed to upholding as a justice of the U.S. Supreme Court. And that's what the U.S. Supreme Court has announced, and that's what it is. So I think, again, we could read into, perhaps some would say she may have different personal views, but what she's saying is my personal views are not relevant. This is what the law is, and that's what I'm following.
And Senator John Cornyn asked about the Supreme Court creating a new fundamental right when it issued its ruling on marriage equality. He seemed very concerned with this idea of the courts creating new fundamental rights, and even asked Judge Jackson at one point, what do you say to people who are concerned and think, well, where do you have the power to do this? And she responded with, we the people. That's where we get the power. We get the power from we the people. So what did you make of that whole exchange? Where's Cornyn going here? And how did you think that Jackson handled that?
I think where he was going, I believe that the senators, and I'm not being critical of it because this is the way the political game is played, they're looking at sound bites that they can use in their next election, use for whatever reason. On both sides, on all sides. And I think what she said was, by saying we the people, that's where we get our power, that's going back fundamentally to the Constitution. She's citing language in the Constitution. And so I think that was a very, I'd say, cagey response to a very, very potentially dicey issue. And again, I think what she's trying to do is shut down, in her way, lines of questioning that she feels are, in her parlance, would cause her to go outside of her lane, how she's identified her lane as a potentially U.S. Supreme Court justice.
As she has identified her lane, I think is the key there, because she's answered a lot of questions about her judicial philosophy today. But I wonder if you think those responses are cagey too, because we've heard in the past justices say, I am an originalist. I believe that the text of the Constitution is to be interpreted literally as it was written, or that they believe that the Constitution is a living, breathing document. It needs to be interpreted within the context of our current world. And here, Judge Jackson is saying, yeah, I don't really fit, or I'm not going to give myself any of those labels. I'm just going to walk you through the 3 steps that I take. 1, I try to clear myself of any preconceived notions. 2, I look at all the facts of the case and the opinions being argued. And then 3, I look at the confines of the law and what my role as a judge, my lane, so to speak, is to go ahead and decide this. It's not really a clear answer, at least not the one that Republicans are looking for. So what do you think of that response? Is it enough to satisfy that?
Well, there's never going to be enough for her to satisfy some of the Republican senators. Let's just state that. And many of them aren't going to vote for her. But I think what she did, and she did it from the inception at the top, she defined her even though she doesn't use the term judicial philosophy, she defined her judicial philosophy, her methodology in going about making cases, deciding on cases. The three things or ways that she analyzes cases when they come to her desk, and saying that that's what she would do as a justice on the U.S. Supreme Court. I think that that is how she's able to cut off and circumvent anyone labeling her. There was a question posed: who do you feel you are most like? I think that was intended to be a softball. They were thinking that maybe she would say maybe Justice Thurgood Marshall, Justice Breyer, Justice Ginsburg. I think they were intending that she would put herself in one of those buckets. She refused to do that. And she goes back to her philosophy of what she does, her methodology. And I think that that's smart, because just think of it. If she aligns herself with any one of the justices, sitting justices or former justices, she's going to open herself up to criticism, because they're going to say, and every opinion that's objectionable, that they would find objectionable by any of those justices, they will then attribute to her. So what she said is, no, I'm not going in that direction. I'm staying in my lane. And how I define my lane and my judicial philosophy is by looking at these three considerations. So I thought that was a way of circumventing what could have been a deep hole that she would be digging and would have had a hard time getting out of thus far.
Now, given that she doesn't need Republican support to get this nomination, so it's pretty much a foregone conclusion, what stops her from just giving really broad or evasive answers to all of the questions?
That is not who Judge Ketanji Brown Jackson is. She is a jurist. That's why she is so eminently qualified for the U.S. Supreme Court. She is a jurist who, while other judges could author an opinion in maybe 10 pages, she's going to take 80 pages, because she testified about this already, wants to make sure that every perspective, that people are very clear that they are heard, both sides, and what her analysis is, how she reached the opinions that she reached. So it wouldn't be sufficient for someone like Judge Ketanji Brown Jackson to just rubber stamp, give some little vague answers. That's not good enough for her, because that is not how she defines herself. And quite frankly, I feel more confident with someone like Judge Ketanji Brown Jackson being exceptionally thorough, analytical, saying what she means what she says, where you understand her opinions, than someone who is going to be vague, where you really don't know where they're coming from. So I applaud her in using that approach, and I think that's just really in her DNA. That's who she is. From what I understand, that's what she's always been like. As a child, as a student in high school, on the debate team, in college at Harvard, and law school at Harvard, and as a jurist, as a practitioner, all of those stages in her life, she has been someone who's been exceptionally analytical, very thorough, and not rubber stamped a single thing. She's an independent jurist, and what she demonstrated in her testimony thus far is exactly what she's saying. She's putting her money, or she's practicing what she preaches. That's a better way of putting it. When she says she's an independent jurist, she is now demonstrating what she means by that, and being way more analytical than many others in her position would be at this point.
So, CK, what are you looking out for as this questioning resumes?
I think when we see these younger senators who have presidential aspirations, or who really, really feel for their constituencies, they need to make a point, because they might feel we haven't gotten under her skin enough. I anticipate that there's going to be more passion, that there's going to be more intensity. There probably will be more disrespect of her, because what as a trial lawyer, one thing that I've recognized from my opponents many times, when they are not able to shake you from your game, then they go low and they start criticizing and saying things that are horribly offensive. I hope we don't see that, because there's been a certain level, not 100%, but a certain level of civility that has surrounded these hearings to date. Senator Lindsey Graham took it kind of low, especially when he was going off in soliloquies and interrupting her and not allowing her to answer, and sort of trying to manipulate the process. The one thing that's happening here is Judge Ketanji Brown Jackson is in control of her testimony. She's not allowing people to let her get off of her game. And that's so important, because guess what? As a justice of the U.S. Supreme Court, we want someone who would not allow anyone to get them off their game. We want someone who's a consensus builder, who's a leader, who's strong in her positions, who's strong in her legal positions, support of the law, Constitution, and all of those things. And she's demonstrating that she is.
All right, CK Hoffler, thank you for the analysis.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.